then they're fitting off of my knee. Talking out the side of your neck like you're insane. Cortisol levels to the roof, inflame. Kids these days so shameless, selling out real friends for a paycheck. Mama didn't teach them no home training. Wanna be me so bad, but they failing. Step to the plate though, I'll take a challenger. I ain't scared of no low life scavenger. I should warn you though, if you haven't heard, I ain't no Colleen ukulele ballanger. Shots been fired, wanna tell that, say it to my face though. Now behind my back, won't be long till you share it in the group chat. And when I call you up, you gonna backtrack. And you should've kept my name out your mouth. Ask me though how it all turned out. When you try to use my name for clout, keep on going, give me something you can talk about.
Hello, everybody. We are here as promised. As usual, there's crap in the scene. Okay, so that's my phone charger. Okay, so Tory Lanez oral arguments just happened. It is 2:42 p.m. Eastern time. So it less than 3 hours ago, the whole entire proceedings started, right? Yeah. Yeah, they started at 12 my time, which was like 9 o'clock in the morning on the West Coast, which is where this is happening. Shout out to the mods in the chats. Hello, Monica. Who else is in here? It's the only mod I see in here right now. Maybe there was one before. I just see Monica. Okay, so live streaming or rebroadcasting the oral arguments today was not allowed unless you got some like special previous prior permission, which I did not do. So I didn't, I was unable to live stream, wasn't allowed to, so I did not live stream. So, here I am now, to tell y'all what I took from it. Before I say anything further, I don't want anybody to take anything that I'm saying as like some type of prediction. Okay. It's very common knowledge that not even the lawyers on cases really can know what the outcome of an appeal is going to be. There's really not very much you can read into the questions they ask, the judges asked, stuff like that. So this video, I'm going to tell my opinion and what I think about things and what I would do if I were a judge, which I am not. Oh, shout out to Make It Make Sense. When is he gonna give it up? I'm gonna tell you, Mims, he has some strong arguments. He does. Now, that's not, strong arguments for is he innocent? That's totally different. He might have done the deed. Okay. He might have done the deed. But we gotta have, fair trials and stuff. But that being said, glad you said that, because at the end of the day, he has been found to be guilty. So overcoming a guilty verdict is very difficult in any and every circumstance and in any and every situation. It's just hard. It's hard to do it. You got to convince 3 judges or at least 2. So first things first, this isn't a prediction. This is just my thoughts, my opinions. I don't have any special knowledge. All I did was watch the public hearing that a lot of y'all probably did too. I do understand a lot of y'all do think that Tory was innocent and is innocent, and that is fair and fine. A lot of y'all don't, think he's innocent. That's also fair and fine. I wasn't there, so I don't know. But that being said, I don't know if this is directed at me, Keys. If so, I'm not really trying to pretend like anything. It's just, I know y'all see what's going on with Milagro right now, right? So people that have platforms especially have to be extremely careful about stuff we say, because there's certain litigious contingencies of people who you do have to be very careful. So even sometimes, you might be able to, this is what happens when I even so much as touch my skin. I don't know. I wasn't there. Okay. But I will just tell y'all about this oral arguments, about the notes that I took, and all that. So that's what I'm going to be talking about. All right. So, I did start reading Milagro's, transcript from her deposition, and I'm not even halfway through with it yet. It's 600 pages long, Well, substantively, I probably am more than halfway through. I'm like in the 200 something pages, but there was so much stuff that was reported in the media that wasn't exactly quite true, or from what I could tell based on her transcript. But that I will save for another day. It's 600 pages long. It's been taking me a long time to get through it, but let me know if y'all want me to read that and go through it, or if you already read it. Hold on, just reading a couple things. Her notes were okay. Ashley said that Milagros' notes were insane and accurate. She told y'all things that they wanted to keep private in the okay, all right, in the media. Okay, interesting. Okay, so I have my notes here. I typed them up on, just like notes or whatever. So I'm just gonna basically just read them. Oops, hold on. Let me just adjust this. Okay. So the trial, not the trial, excuse me. The oral arguments were today. He has appealed his criminal conviction. He is standing. I don't know if he was actually there. The only lawyer I saw for him was Crystal Morgan. I don't know who else was there. But that is his defense attorney's name. Now she stands up and she has reserved, I think, 30 minutes for oral argument and or requested 30 minutes. And then I think she reserved like maybe 5 minutes at the end for rebuttal. She started off her speech. Again, this is just from my notes. It's not going to be verbatim. I was just kind of like typing as fast as I could to get the main points. So this isn't like a transcript or anything, which I'm sure there will be one circulated at some point. Okay, so Crystal Morgan, who is Tory Lanez's lawyer, starts off saying that like any apology that Tory Lanez may have given to anybody should not be considered to be an admission of guilt. First things first, she's like, him saying that he's sorry for something, like we can get into the arguments of whether or not, what he's sorry for, but just straight off the bat, Tory's lawyer, Crystal Morgan, said any apology that he may have issued to any doesn't mean that he was saying that he's guilty. Admission of sympathy is not an indication of guilt. Now, she did say that what she believed were Tory's most compelling arguments stem from the confrontation clause, which is that criminal defendants in the United States have the right to effectively and thoroughly confront their accusers when they're being accused of criminal wrongdoing. The second argument, which she thought was most compelling, I don't know if she was going in order like the second most, but she said 3. So the first one was the confrontation clause. We will get into that. Second one was the prosecutorial opening. So the opening statement and the closing arguments were indications of a prosecutorial misconduct. And the third big issue, and she said these are their most compelling arguments. And I do agree with her on this third one. Before even hearing her arguments, like what have I been saying this whole time? Like, I think the most compelling arguments are specifically the Brady ones, the fingerprints, the DNA, the fact that there was transcripts of things that Tory Lanez lawyers did not have, the fact that they didn't know about certain DNA evidence until like the night before, certain things not being able to run through their own experts, not being able to make certain arguments because of the untimely turning over of evidence, which in my opinion is suppression, which counts under Brady and its progeny. Now, Brady has other cases kind of like that came after it Brady versus Maryland wasn't strong enough. There's more cases that come after Brady that even give the defendant, or not give, reaffirm and solidify defendants, and that includes me and you or anyone in the United States who is ever accused or charged with a crime. There's certain rights that come into play. And so they start off with the confrontation clause. This is the first kind of like round of arguments that Tory's lawyer makes. Is this like, first of all, let's start with the confrontation clause stuff. Okay. I know a lot of y'all are concerned more about DNA or fingerprints, or why didn't they run certain DNA, or why, 911 calls. And we will get to that. But where she starts is the confrontation clause. She says Kelsey, and this is Tory's lawyer. She says Kelsey Harris was present in court And in confrontation, Kelsey testified on December 14th and December 15th, but she testified after invoking her Fifth Amendment right to basically not testify. But then the government came in and gave her immunity and ordered her to testify. So then she became available. The confrontation clause, TORY's lawyer said, has fact-specific analysis that we do have to run in order to figure out, was the confrontation clause violated? So she's arguing all this stuff. And she says, and this is a sixth. Okay. So she goes on and says this fact-specific analysis would balance. I always forget my scale when I need it. Okay, there's one back there. Can y'all see it? No. Can't even see my scale. I got so many of them. Okay, I'm gonna bring one next time. Okay, so you have two sides of the scale. Okay, and this is because two people have rights. Kelsey Harris has rights. Yes, she does. I know y'all don't like her, but she still has rights. All of us have these rights. They're not, so that's the equal protection clause. It's not supposed to matter if you black, white, brown, any other color. It's not supposed to matter where you were even necessarily born. It's not supposed to matter what religion you practice. The law must apply equally to everyone, in particular constitutional protections. So Kelsey has rights. What's one of her rights? Fifth Amendment, just like yours, just like mine. Wait, what did I eat up, Big Peach? Oh, thinking that it was going to be Brady stuff. Yeah, she did. I will say she did do a great job. I do want to say that as well. I'm not familiar with Crystal Morgan, never heard of her before this case. I will say that she did a great job. I was very impressed for, seeing her for the first time. I feel like she commanded the room well. I feel like she just in general made great points, great arguments. She did a good job kind of condensing it down. I think she did a great job. The prosecutor didn't do a terrible job, but in his, frankly, in his defense, he has a hard he was kind of starting in an uphill battle because I think some of these Brady things, but that doesn't get argued about yet. I want to go in order of my notes here. So I will be poking in and making some of my opinions and maybe reading some comments here and there, but I am going to go in order of what my notes say. So, so you're weighing the lawyer, and this is still Tory Lanez's lawyer. She's talking about her first. Remember, she said there's going to be three big major points we're going to talk about today, and I think these are my strongest points, Your Honors. Confrontation clause, the opening and closing statements having to do with like not a fair trial and stuff like that. So that's two things, right? Confrontation clause stuff said by the prosecutors during the opening and closing statements. And then the third big issue, and I believe I agree with her, this is the strongest argument, is just cumulative Brady violations. And I have discussed these Brady violations over and over again. So go check out the Tory Lanez playlist if you want to get a little bit more analysis on the Brady stuff in real time as I've been reading through the transcripts. Now, I'm still not done with the transcripts. Namely Sean Kelly. I still have to read his. Or did I read his? I might have read his, but I do still have to read other stuff from his, like his initial statement and things like that. So, again, I'm not even familiar with every single word that was said at trial at this point because I'm not even done reading the transcript. So take things that I say, y'all, with a grain of salt. I do understand, acknowledge, and appreciate. A lot of y'all have been here for a long time, 5 years more, some of y'all. So I'm not trying to say I know for sure. This is just my analysis, my opinion. Take it or leave it, truly. I'm just, I just listened to the oral arguments and took some notes. I'm telling y'all what I took from it, but it was public. So I did not. Okay, thank you, Simply Fee. I did not read his testimony yet. I did read just his interview, right, on that Saturday, December 17th. Okay, so she's on the first part, the confrontation clause part. She's like, Kelsey testified the 14th and 15th of December that year, but that was after she got immunity. We're balancing Kelsey's rights against Tory Lanez's rights. Okay, so Kelsey has a Fifth Amendment right. We all agree to remain silent, to not testify. Specifically, why do you have the right to remain silent? This is not legal advice. If you need legal advice, go hire a lawyer because I'm not your lawyer. But and I do not represent clients. But Kelsey has a Fifth Amendment right not to self-incriminate. You have this right not to speak. You have a right to remain silent because anything you say can be used to take your rights away, put and lock you up, basically. So you don't have to talk. And especially if it's something where you could actually get in criminal trouble, you have a right not to talk. However, sometimes these rights come up against and conflict with other people's rights, right? Like we have the right to free speech, but we don't have the right to make violent threats because that's infringing on someone else's right to be safe and free where they live or whatever, right? So Kelsey, yes, she does have this Fifth Amendment right. Tory Lanez lawyer says she does have the right to remain silent. However, my client, Tory Lanez, also has rights, and that includes his Sixth Amendment right to confront witnesses against him. And she says now this confrontation clause analysis is a step-by-step test. Number one, you have to determine, was it a testimonial statement? And so what exactly the piece of evidence that the lawyer is taking issue with on this confrontation clause thing is that interview. Y'all remember that interview where Kelsey was, it was just a few months before trial. It was like September 2022. She met with the prosecutors. It was recorded. Her husband was there and she said all kind of stuff. And then she came back a few months later to actually testify at the trial. And when she came to testify at the trial, again, she invokes Fifth Amendment protection, and then they give her immunity. But she kind of like changes her story a lot on the stand. And then she also says stuff like, I don't remember, or I wasn't truthful. She admits that she wasn't truthful during that interview. And so her story kind of ends up being all over the place. So was it a testimonial statement? Were the statements that she made there testimonial statements? And the answer has to be, I think, yes, because they were made when an emergency was no longer present and they were in response to a prosecutorial event. And Tory's lawyer said that means Kelsey's interview with the district attorney's office was a testimonial statement. She did it under oath. She did it knowing that it was in response to a prosecutorial event. So step one has been proven. Again, y'all, this is not the Brady stuff, which we're going to get to. I'm going in order. This is the confrontation clause. You have a Sixth Amendment right to confront people that accuse you of stuff. Everybody does, especially if you're a criminal defendant. So she's like, yeah, number one, step one, it's obviously a testimonial statement. Then number two, they had to determine whether or not Kelsey was considered to be available or unavailable. And that's a legal term of art. Now, the lawyer, Tory's lawyer, said we got to take a step-by-step analysis because at first, whenever Kelsey said, I plead the Fifth, that made her unavailable. Right. I'm putting quotes around available and unavailable because these are legal terms of art. It's not how me and you would just use it. Are you available to have a Zoom call? That's not the same meaning of like available. There's like, capital A available. So when you say, no, not available, right to remain silent, invoking, plead the Fifth, whatever, you're unavailable. However, when you're ordered, after you do that, the judge says, no, you have to, but we're going to make sure you're never prosecuted for anything you say up here, as long as you're truthful. Then Kelsey became available. So she was available to be confronted under the confrontation clause. Then Tory's lawyer goes on and says, also, Kelsey admitted to being dishonest in those first statements in the recorded interview. This directly, and then on the direct by the Fed, no, excuse me, not the feds, the state, the prosecutors, on the direct examination, they actually played portions of this recorded statement to so-called refresh Kelsey's recollection. Remember, it's like, oh, we're gonna refresh your memory. Would it help you? Would it help you if you heard the tape again? And this is where in the transcript, George Magdesian, Tory's lawyer at trial, was objecting. He's like, what are you talking? What? No, I don't even have a transcript for this. You can't play a tape, a video recording in open court to the jury and let the jury hear. When I didn't know this was coming in as evidence, I don't have a transcript for this. And that's whenever at the sidebar, the judge was like, this is just easier. And remember, I made that whole entire two-step analysis between Diddy's trial and how they had headphones and how refreshing someone's recollection is like a bad reason to play something out loud in front of the jury because the jury is still going to hear it. Now, the jury did hear that. And not only did the jury hear those clips, just to refresh the recollection. But on cross-examination, the prosecutors started indicating that they wanted to submit the entire recording, not just sections, but the whole thing. They wanted to sit there for an hour and a half and let the jury listen to the whole interview. But this wasn't while Kelsey was giving her testimony. It was actually entered on December 16th, and that is when TORY finally received the transcript. Okay, so again, I personally don't believe this is the strongest argument because I think it is a little bit attenuated. I think it's a little bit attenuated. That means it's a little bit more complicated. It's not quite so cut and dry. However, that doesn't mean that it's not a decent argument. Shout out to you, Sean Davis. Thank you so much for this very generous super chat. Hope you and everyone in chat are having a great start to their week. I see your drum is on stand, but you see it? You see it? I kind of got my bell in the front here too. Thank you so much for that $75 super chat. Thank you so much for that. Okay. I was hoping BJ was going to come back with an, I don't know, AI song like she did the titty trial. Not yet. Not yet. Maybe I'll make one. Or maybe I will prompt the AI to make one. Okay. So on cross-examination, okay, so Kelsey's trial, her testimony at trial was on the, let me make sure I'm saying the right dates here. I do have it written down here. I don't have it written down. I think she testified on the, somebody correct me in the chat if I'm wrong. I think it was yes, okay, I have it right here. Kelsey testified on the 14th and 15th. Okay. But it wasn't until the 16th, so the day after Kelsey testified, whenever TORY's lawyers finally received the transcript. Now, under the confrontation clause, what TORY's lawyers are arguing is that because, and I think it's a strong argument, although not the strongest one, there's levels to this, but I do think it's a strong argument. And I do see how Crystal Morgan has laid it out very expertly in her team. But what they're basically saying is because TORY and his lawyers didn't have that transcript of that full hour and a half long thing while Kelsey was testifying, that prejudiced TORY. And the reason it prejudiced him was because he didn't get a fair trial. He didn't get a fair trial under the Sixth Amendment because he had rights which were violated. This is TORY's arguments. His lawyers. His right to confront Kelsey was violated because his lawyer didn't have all of the evidence he needed in order to combat this, what he's arguing is prejudicial evidence, which was played in front of the jury. It wasn't even supposed to be admitted as evidence, but the jury heard the whole thing played out. And then the prosecutors were like, okay, well, we're not doing it to refresh her recollection now because she's gone. So what was the reasoning that they did that? The reasoning that they gave for doing that was that they were trying to impeach her, which I think is a very weak argument because why would you want to impeach your witness? They weren't doing it to impeach her. Tory Lane's lawyers are basically arguing. They were doing it to get this version of the story in that they like better. And they didn't give Tory his right. They violated his right to be able to really confront her meaningfully on that. And so I think it's a strong argument. Thanks so much for the $1.99 super chat. New life plan. Love your commentary. Mean it. It's not an anomaly, Bree says, to receive the transcript a couple days after, and he still refused to take the stand. Well, these two sentences have nothing to do with each other. So I'll take them one by one. It's not an anomaly to receive a transcript a couple days after. Maybe. But I do think it's an anomaly to have an hour and a half long video, which was not submitted for evidence purposes previously, to be played in front of a jury. After the witness who is supposedly saying these statements has left the stand, I actually don't think that it's common at all for something like that to happen. But if you have some cases where you can show that, I would be happy to take a look. Second sentence, he still refused to take the stand. That's his right. He has the right to do that. You have a right not to testify against yourself because the burden to prove your guilt is on the prosecutors. So So what? I mean, speaking of things that are not anomalies, it is absolutely not an anomaly for someone not to take the stand in a criminal trial. In fact, and indeed, it's kind of common. So hope that clears that confusion up for you. Okay, so moving on. So again, like I said, at first the state had argued that it was using this evidence to so-called, impeach Kelsey because they weren't, she wasn't saying the same thing she was saying in that previous September interview. And then also Tory's lawyer said during the opening statement, the prosecutors said that Tory Lanez had pulled Kelsey by her hair and the evidence was going to show that, but then that never actually ended up being proven at trial. The lawyer said that was one of the sort of opening statement, inappropriate things that was said in the opening statement. And remember, that's one of the three pillars holding this appeal up. The three pillars of the appeal are confrontation clause, opening statement, closing statement, and then, or opening statement, closing argument. And then the third thing is the Brady stuff. Okay. So, some of these things kind of like go into, more than one of these buckets. And that would be the Kelsey video. It's kind of being used to support two pillars. Then Tory's lawyer goes on in this argument, the confrontation clause thing, but she's giving other reasons why the interview shouldn't have been admitted in the way it was, this Kelsey interview. She says also there was the late discovery of the transcript, which we've discussed, numerous other instances of late discovery that the trial attorney did preserve for appeal because he did object. And Tory's lawyer said this is a very unique situation because this is a testimonial statement where a witness wasn't wanting to give answers. She admitted to lying just a few months earlier. She was uncooperative. And so Tory's lawyer said, as a result, we really need to look at the reliability and the prejudice to Tory. Because she actually stated she did not tell the truth. And so Tory's lawyers, I don't know if they're claiming they weren't able to accurately like push on the did not tell the truth stuff. Again, I don't think that this is the strongest argument, which we will get to. But and when I say I don't think it's the strongest, that's not me saying like I don't think it's strong, but there are many arguments, and I think it's kind of, like I said, it's kind of in levels. And then Tory's lawyer said that this cumulatively prejudiced Tory Lanez because the jury heard statements from the recording. They relied on statements from that. And the lawyer says she knows the jury relied on statements from this recorded interview because at deliberations, the jury asked for those recordings. For that transcript. They wanted to look at the transcript. So they did rely on the transcript in their deliberations. And his lawyer said they asked for a copy of the transcript. And so for the totality of the circumstances, the lawyer says Tory Lanez's lawyer says that he did not have a chance, the proper constitutional chance to really confront Kelsey, the witness, as he does have a Sixth Amendment right to do. So, okay, interesting. That's one argument. And I remember there's three pillars. There's three pillars that are holding up the argument for appeal. So the second one is the opening statements and the closing arguments. Okay, that's the second number for this appeal. The second pillar of this appeal that Tory's basing his arguments on. So in the opening statements, apparently the prosecutor, and I did read those transcripts, but I don't remember every single exact thing. But the prosecutor promised in his opening statements that he was going to put Justin Edison on the stand. Justin was going to say that the next day after the shooting incident that he met with Tory and Tory confessed to him. So this was said in the opening statements. We're going to put Justin Edison on the stand. Justin is going to say Tory confessed to the shooting. Okay, they said that in the opening statements. However, as you may know, Justin did not testify. Justin Edison did not testify. He was uncooperative. So actually, after the trial, there was some type of body attachment put on to Justin. I don't exactly know what that is, but it would indicate that he was an uncooperative witness, I think. The trial attorney, that's Tory Lanez's lawyer, George Magdesian, he filed a motion in limine. He was concerned that Justin wasn't going to come to court. And he was concerned that Justin not coming to court was going to severely prejudice Tory. He asked the judge oh no, this was before the trial started. Okay, excuse me. Before the trial ever started, right? The trial was in December 2022. So the month before, at the end of November, there was this body attachment, and there was a motion in limine filed, according to my notes. Okay, I might have misinterpreted something, but this is how I heard it. And there will be probably a transcript. So once that comes out, we could check. But the trial attorney did file. So George Magdesian, Tory's trial lawyer, did file a motion in limine. That's where you're trying to exclude something from being able to be said. He did try to get it to where the prosecutors were not going to mention this so-called confession. And the reason was George Magdesian, Tory's trial lawyer, who stepped in just a couple weeks before the trial started to be Tory's lawyer. This George Magdesian guy said, these statements about Justin are prejudicial, that my client confessed. They don't have a good faith belief that this Justin Edison is even going to come to court. And then it was put out that he didn't show up because of media coverage. And it was implied that Tory Lanez was responsible for Justin not testifying and not showing up. And the lawyer says this just wasn't true. So she goes forward and says that there is a rule. There's a rule that needs to be considered here. And it's about opening statements. And opening statements have to be confined to a reasonable, good faith belief by the lawyer, right? So the prosecutor has a rule, and so does the defense. Everybody doing an opening statement, they have to have a good faith belief that what they're saying is going to be actually done or proven or shown at trial. And so Tory's lawyer said the prosecutor had no reasonable good faith belief that Justin was going to come and say that Tory confessed, because Tory had been a completely because Justin Edison, this witness, had been a completely uncooperative witness, period. They had no good faith belief, because Tory's lawyer today said they don't have any evidence. Tory's lawyers, she said, I don't have any evidence that these prosecutors ever even once spoke to Justin Edison, ever. Not once. So there hasn't been an establishment of a reasonable good faith belief that he was going to come in and say that Tory Lanez confessed to shooting Meg Thee Stallion. Then the lawyer goes on and says, that's not going to, but wait, it gets worse. She said there's no limiting instruction. Usually if something like this were to happen, you say something in the opening statement that doesn't end up being proven at trial, that the court would come back around and say, hey, remember that thing you heard about confess? That didn't end up actually turning out to be true. But there was no such limiting instruction, and there was no such curative effort in this case, she says. So about this time, the judge butts in and asks a question. One of the judges, there's 3 judges on this panel. She said, so are you trying to say that anytime there's a body attachment on a witness, that the prosecutor should just know that, there's no good faith effort, there's no good faith belief of something that they've said? Or like, what exactly are you, exactly saying? And I think that that's a good question by the judge. And I think it was a good answer by Tory's lawyer. She said, no, Your Honor, I'm not trying to say that just because there's a body attachment and a witness has been thus far uncooperative, that there's no good faith basis upon which you could, say in an opening statement that you hope. But she said, Your Honors, with all due respect, maybe the prosecutors should have said something like, we hope to prove, we hope to show, we expect, or, we have a report where someone said this. But to just come out and say you're going to hear from someone who's going to say that this man confessed, and at the same time, you never actually even talk to that guy, you just saying it, that's not a good faith belief. That's not strong enough. And I can see where she's coming from on that argument. I absolutely can. So that's how she answers it. And she says there's no proof that the prosecutors ever once spoke to Justin Edison. Never. She said, Tory's lawyer said, so we cannot ascertain the veracity of these statements in this specific case. They had never spoken to the prosecutors, never even talked to him. So why did they stand up there with their full chest at the very beginning of the trial whenever they know or should know that jurors are more likely to give credence to a prosecutor, not to think a prosecutor is just lying? And this is just out the gate before TORY had the chance to put on his defense, before anything. It comes down to this good faith basis. Now, do I think that's strong enough to overturn the entire case, the entire trial? I don't know. Probably not alone. Probably not standing alone, and that's just my opinion. But part of the argument here is that all of these things cumulatively led to an unfair trial. In addition to the three pillars of the argument, right? Each one is kind of helping to support the whole thing. So it's a cumulative effect. So that was as to the opening arguments. The opening arguments have to do with, you're going to hear from Justin Edison. He's going to come and say TORY confessed. But all the while, the prosecutors had never even spoken to him and knew that he was uncooperative. So that's, the opening. So then she gets into her issues with the prosecutor's closing arguments, which I haven't read yet. But the lawyer for TORY said that there were inaccuracies. There were misconstrued results. She gives examples. She says, for one, the DNA evidence. She really spent some time talking about this "don't be surprised" or "don't be fooled" terminology. Apparently in the closing arguments, one of these okay, hold on. I got to get rid of some Media Matters bots out my chat. Okay. I've had enough. Because there's like some accounts in here, it's like you're entitled to your opinion, but like you're entitled to your opinion, you're not entitled to come in here and try stir and start fights. Okay, you're not entitled to do that. So blocked. Goodbye. Okay, so she gets on to talking about the closing arguments. She says an example she gives is this thing that they said, the prosecutors apparently said in the closing arguments, like, don't be fooled. Don't be fooled by Mr. Peterson and his attorneys or whatever, whenever they stand up here and say that he was excluded from DNA evidence. And the lawyer says that was very misleading because their own evidence, their own DNA evidence, the prosecutor's own evidence that they provided said he was excluded, at least as to the magazine. And he was excluded. And I'm glad she made this clarification point because I hadn't really thought of it this way, I'll say. But I think she's right. She said he was excluded in a lot of ways as to the DNA on the gun. Because why? Well, there was 4 DNAs that they were able to say were for sure 4 different DNA profiles on the gun. One was a male, and it was over like a 90%. You know how that those percentages? So one of the percentages was 90%, and it was a male. And even some people in my live chat, my comments, have been saying, yeah, well, there's a 90% male DNA on there. Everybody's forgetting that. That was obviously him. Screech halt, slam brakes. And the prosecutor did not dispute this. The 90% DNA that's a male on the gun did not match Tory Lanez. Like they were able to run that one. So the 90% match was a male. And according to Tory Lanez arguments, Tory Lanez lawyers' arguments today, it was someone who's African American. That's what she said. I don't know if you could tell that from DNA. I'm sure you can or whatever. But she said it's much more likely someone else put that DNA, not prints, excuse me, DNA. She said, so this whole closing argument of like, don't be fooled when he says he's excluded. The lawyer was like, that's actually very misleading because he was absolutely excluded in many ways. Now, should she have gotten up there and said that he's excluded from having left DNA on the gun? No, because it's inconclusive. And that is whenever she said, I think, Your Honor, it's actually important to discuss some scientific definitions. We need to talk about what terms mean, she said. She said, inconclusive when you're running a DNA test, it doesn't just mean neutral. It's more complicated than that. She said there's something called the scale of likelihood ratio. Likelihood ratios are the percentages We did not hear any percentages in TORY's case. Only given to the defense. Okay. So there was some evidence. There was some DNA evidence that was not turned over to TORY's team. And this is where Brady starts to peek in. There was some evidence that was for DNA that was not turned over to TORY's team until his lawyer asked for it. But the evidence was not presented in trial. They labeled TORY's sample to be, quote, inconclusive and uninformative. But what really was shown was that there was a 1 out of 1 million chance that his DNA was on this gun. And the jury never heard this fact. So I don't know if this is a fact or not. I'm just telling you what the lawyer said. She said that she got, not in evidence, because she wasn't on the trial during it going on. It was this George Magnesian. This lady is new, Crystal Morgan, I think, her last name. So she said, Your Honor, the way they put it was inconclusive, uninformative, but the jury never heard that there was a 1 out of 1 million chance. Like if you're about to, play the lottery, is 1 out of 1 million a very good chance? No. There's a chance, but 1 out of 1 million is not a good chance. And put together with the fact that there was 90% DNA found of another male who's definitely, certainly not Tory Lanez, these things should have been presented to the jury, and Tory's lawyer saying that they just simply weren't. She said it's actually more likely someone else who's African-American touched that gun and not Tory. But the prosecutor got up there and said, don't be fooled. But Tory Lanez didn't fool anybody with the DNA. It was the state who ran the DNA. She said, we went off, our client's lawyer at the time went off what the state's evidence said. We didn't even disagree with their evidence. So why the don't be fooled argument and terminology? So then she gets into the standard for prosecutorial misconduct. And this is important for the overturning or not of the case, because certain things like what can the appeals court actually do? They can allow the ruling to stand. They can say, no, we're leaving it. So Tory Lanez would have to appeal again to a higher court, which I think the next court up is the Supreme Court. And maybe not, maybe there's one more, but I do think the next one up is Supreme Court. And then, or they could exonerate him or declare a complete total mistrial, which means he walks free, no more trial again, or they could do a retrial. So those are the 3 possible outcomes. Nothing, he stays in jail and he has to appeal to another court. That's 1. 2, he walks free, skipping down the street and is never tried for this ever again. Or, I don't know if I said 2. Or 3, he has to go through the trial again. Now, nobody on planet Earth can tell you, other than maybe the judges, what that's going to be. I would be surprised. Actually, I'm not even going to say. I'm not even going to say nothing. I'm not going to say nothing. I'm not even going to predict, because no. So I think he has strong arguments. I'll say that. I think especially the strongest argument we haven't even really gotten to yet, but we're starting to peek into it. And that is the prosecutorial misconduct. Okay. So if there's just a little oopsie daisy error here or there, there's a chance that, there's another trial. However, if prosecutorial misconduct is found, this isn't whoopsie daisy. This is something that's like, there's rules for this, and you just went so far beyond decency. So Tory's lawyer said that, there was prosecutorial misconduct on the part of the prosecutors. And so she said, the standard is, number 1, there's 3 things. There's 3 things that have to be shown for the prosecutorial misconduct step or test. And if they can prove prosecutorial misconduct on even one of these, I'm pretty sure the whole trial, he walks free. There's no more retrial. There's double jeopardy if they try it again. That's my understanding. Again, I'm not an expert, nobody get your hopes up. However, prosecutorial misconduct is very closely and intimately related to Brady violations. And if there was like an intentional suppression of evidence or something that was so egregious and reckless, like the whole trial could get turned over. And there's a few different Brady violations argued. The cumulative unfair effect of these cumulative taken together bunch of Brady violations. So the standard is a 3-part test. Number 1, did the suppression of the evidence materially affect the outcome of the trial? So in this particular place, what evidence she's talking about had to do with the inconclusive, uninformative, 1 in a million chance that Tory Lanez had his DNA on there. The fact that he was excluded, at least as to being the 90% male contributor. Then there were 2 other women profiles on the gun. So that leaves 1 possible male, possible female contributor, and you don't know if it's Tory or not. So for that part, I do think that is inconclusive, but the jury never heard 1 in a million chance. So Tory's lawyer is saying because they never heard that, it should be, turned over. And that's because the DNA test that said that was never turned over to Tory until they asked for it, which is, if that's how it happened, a Brady violation. So, number 2, so that's the first one, right? Like, did the fact that this DNA evidence wasn't turned over in a timely fashion, did it materially affect the outcome of the trial? Well, Tory's lawyer said, yeah, but that's not the only evidence that would apply to, right? There's a lot of Brady arguments here. Number 2 in the Brady test, it did affect the outcome of the trial and it was material. And if the jury heard, okay, so she's basically saying if the jury had heard the 1 out of a million chance he touched the gun, it would have been enough to perhaps tip the scale, even just that. But instead, the jury heard that Tory was going to try to trick them or fool them or hoodwink them. And so taken together with what was said in the opening statement, the closing statement, and the lack of evidence being presented in a timely fashion, especially until the defense lawyers asked for it, this resulted, according to Tory's lawyer's argument, in prosecutorial misconduct, which should result in a mistrial and he should walk free, is her argument. Now, again, Brady, I do think, is the strongest argument, but maybe not specifically with respect to this statement. Like, there was a 1 in a million chance the DNA was on the gun. His DNA was on the gun. However, I do see their argument when you add and this, and this, and this. But do you see how it is kind of attenuated? Like, you still do have to say a few different parts. And it's like, if A, then B, and if A and B, then C, and if A and B and C, then D, versus like, they didn't turn fingerprints over, the end. Like that's it. Like, this kind of brings in this opening statement, closing statement thing, which allows a little bit more wiggle room under the law. However, cases have been turned over for Brady for, time immemorial. So it could happen. So then she moves to another alleged Brady violation. This is Tory's lawyer. And she says that it was that Instagram post. Now, that Instagram post is something about the shooting. And then somebody says, somebody comments, Kelsey did it or whatever. And then the verified Tory Lanez Instagram account with the blue check mark comments under Kelsey did it. And he comments, that isn't true. That's not true, or that isn't true. Well, the way it was presented at trial was as if Tory Lanez was the only person who could log in to the Instagram account. So he must have necessarily been the one who posted that. But Tory Lanez said he did not post that. He didn't post from that account. His social media manager had access to it. Guy's last name is Farias. This Instagram post, according to Tory Lanez lawyers, was given over to them late. It was unredacted. It was riddled with hearsay, and it implies a confession. She says the reason it implies a confession is because there's only 4 people in the car. One of them got shot, so can't be her that's the shooter. Allegedly got shot. I don't know. I wasn't there. Jaquan was the driver and was, pretty much never suspected as being the one to do it. So they're really only left open 2 people who could have did it, could have pulled that trigger if one was pulled. And it would be Tory Lanez and Kelsey. Both of them had gunshot residue on their hands. So we need more information. So if, the prosecutors want to show something up there as if Tory Lanez said it, and what the statement is that it's not true that Kelsey shot the gun, then that must be Tory shot the gun. That's kind of what the lawyers are arguing. I also, again, do not think this is their strongest argument, although I don't blame them for trying to make it. The reason I don't think this is the strongest argument is because the jury at least did hear an aggressive cross-examination, which I think George did a good job. A very aggressive cross-examination where it did bring up, is it your knowledge, your understanding that most celebrities have people who can access their Instagram? Do people post on social media for them? How do you know for sure that TORY is the one who posted this, et cetera, et cetera? So that's why they're saying it implies a confession, because it kind of like eliminates Kelsey, and it makes it look like Tory's saying Kelsey didn't do it, and that really only leaves one person who could have did it, and that would be TORY. So the lawyer said that was supposedly supposed to be an admission, but many celebrities don't actually run their social medias. The discovery was untimely. She said we could have had the statement that we ended up getting later on from the social media manager. Ended up making a declaration in the appeals case saying, I'm the one who wrote that comment, blah, 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 blah. Now, they didn't allow that evidence in, but the lawyer is saying that evidence wouldn't have to be allowed in or not allowed in at the appeal stage if we were allowed to get that statement from the lawyer at the trial stage, from the social media manager at the trial stage, but we were not able to get the message, the declaration from the social media manager at the trial stage because we did not have timely notice. So again, they're arguing that this is a Brady violation. Always in a position. Okay. She said, yeah, even at trial, the lawyer, George Magdesian, was saying that he was always in a position to react instead of actually being able to produce a defense in this case. He was like, every day, he's like, I'm getting an email late in the morning, early in the morning, late at night. Oh, oops, we forgot to turn this over. Oh, oops, we forgot to tell you this. Oh, oops, we forgot to turn this over. And it ended up making a situation where the lawyer was just trying to just react to stuff instead of actually putting on his defense. So then one of the judges actually asks a question, interrupts the opening and asks a question. He says, well, you make arguments about this Instagram post being unredacted, but were there ever any requests by George to redact it? And Tory's lawyer said she believes there were. And then that's when she took the time to remind the judge, that George only had a few weeks to prepare for this trial. She said he only took over a few weeks before the trial began because the first trial attorney was all of a sudden, withdrawn and allowed by the court to withdraw. And she says, and also, Your Honor, requests for redactions and requests for anything, just to remind you, like exculpatory evidence has to be given to the defense, even if the defense doesn't ask for it. Like that's part of the law. And she goes back again into this Brady test. She says it's a 3-part analysis. Number 1, is the evidence favorable to the defendant? She says, yes, Your Honor. These are evident. There's many cases of Brady violations here, and I'll just name out a few where the evidence was favorable to TORY. She says, number 1, and I think this is the weakest argument, but I will run through the argument. She says, number 1, the Instagram post was actually favorable to Tory Lanez. I don't agree. The Instagram post where Tory Lanez blue checkmark account said Kelsey didn't do it, basically. I mean, he said that's not true, but under the thing, that's not favorable. That's not favorable to Tory Lanez, because it looks like a confession, but he can and did, I think, rebut it when he was, did have the time to, and so I didn't write that. And I think he rebutted it too on cross-examination. I do think the jury was left with a reasonable doubt as to who exactly posted that. So I'm not exactly sure that this specific Brady violation is going to get us, to the point of a retrial or a mistrial. But that being said, she names other supposed Brady violations like the DNA evidence. She said, if we would have had that DNA evidence in time, our DNA expert could have better prepared for the defense. Another example of the Brady violation, Brady material that would satisfy this, number 1, there's 3 components, right? The first component is that the evidence must be favorable to the defendant. That would be TORY. The Instagram post, I don't think it's favorable to him, but there's many, examples. Number two, DNA evidence should have been prepared, should have been turned over in a timely fashion. And it was supposed to, all this stuff was supposed to be turned over by 30 days before the trial even started. So, and the fact that it didn't get turned over to them, so I think after, it wasn't even presented as evidence in the trial at all. Another piece of evidence that TORY's lawyer offers up as satisfying this first prong of the Brady components, which is that the evidence which was favorable to Tory Lanez would have also been Kelsey's interview, which they didn't get the transcript for until after Kelsey got off the stand. Another one was that she could have been questioned on cross-examination, but she wasn't able to be because they didn't have the transcript. She also did mention what I believe is the most important. I still believe is the most important. She said the fingerprint evidence showed Tory's fingerprints were not found on the weapon. Attempting to have, and then she said, on top of that, Your Honor, they didn't run the serial number of the gun. They just said, we can't find out who it's for. They didn't even try to find out who it was for. She said, but now, Your Honor, we are attempting to have them run a serial number on this gun to see who actually owns it. This was not done. It was tried to be proven at trial that my client owned that gun. There was no fingerprint on that gun. There was no DNA of his on that gun, which could be conclusively found. There was no DNA. There was no fingerprints on the magazine either. The jury never heard about the fingerprints on the magazine. The jury never heard about no fingerprints on the gun. And the jury never heard that he was excluded, or maybe they did, but was told that they were being fooled whenever it was said that he was excluded as a contributor of the 90% male DNA. She said that we're not done, though. We're not done. There's also a recording / transcript we still never got of one of the key witnesses in the trial, Sean Kelly. We have no copy of his 911 call to this day. And that's whenever I said that's a whole nother Brady violation on its own. Like, that's enough, in my opinion. And I don't know, because I don't know if this is necessarily true, although I have no reason to believe Crystal Morgan would be lying. But like think of it this way, y'all. I know there's people in here that are like, can he stop? But think of it this way. Think that you are on trial for something. Think you're on trial for something, and the police have all this evidence, and it's like quintessential evidence, like fingerprints and DNA. Not only did they neglect to run they should have ran everybody's DNA in that car. It's only 4 people. They should have ran everybody's DNA on the gun and the magazine, including Megan. I want to know, did she ever touch that thing? Is it hers? I can ask that question because it actually was never established at trial. The prosecutors never even said it was Tory's gun from what I've seen so far. All they were trying to make it seem like was that it was his or his security. It was like an implication, which is allowed, but what's not allowed is suppressing evidence. Imagine your fingerprints are not on the gun. Imagine your fingerprints are not on the magazine, and they're trying to say you pulled the trigger. Don't you think that evidence should come in at trial, even if you pulled it? It's something. Okay. So then number 2 on the Brady thing, right? So number 1 is was the evidence favorable to defendant? And so she named a few. What I'll say I think was favorable to defendant was the DNA that showed the 90% match wasn't there. That was untimely turned over. I think it was favorable to Tory that there was no fingerprints on the gun and there was no fingerprints on the magazine. Okay. I think that helps to make it look like he didn't do it, right? That's what's called favorable to. And then, I don't know exactly what was said on the Sean Kelly 911 call. Neither do any of us, unless, you're somebody who does know, I guess. But it sounds to me like even Tory's lawyers don't even know what was on the call. So I don't know if it for sure was favorable or not. However, it doesn't actually matter because Brady has been expanded through like this Giglio case and these other cases to include inculpatory evidence, basically any material evidence. But we're just talking about Brady, and she's saying it still qualifies. Now, number 2, after the evidence has to be favorable to the defendant, the second Brady rule is that the evidence was suppressed. Was the evidence suppressed? Number 1, was the evidence favorable to the defendant? So let's just go fingerprints. His fingerprints aren't on the gun. His fingerprints aren't on the magazine. Yes, obviously that's favorable to him. If they're accusing you of pulling the trigger and your fingerprints are nowhere on that gun, but other people's fingerprints were, obviously that's favorable to you because you're being accused of being the one touched it, but your fingerprints ain't on it. So, number one, yes. Number two, was the evidence suppressed either willfully, or accidentally? Either willfully or accidentally, was it suppressed? The answer is obviously yes, even if it was an accident, because the prosecutor did say they didn't even know about it. They were going to not going to use it. I bet y'all weren't going to use it. I bet y'all weren't going to tell the jury his fingerprints wasn't on the weapon. I bet y'all wasn't. But that doesn't matter whether they were going to use it or not. What matters is it favorable? Number one. Was it suppressed? Meaning not timely turned over. It could still be considered suppressed even if it was eventually turned over. Now, it's a stronger suppression if you never got the information, which is the recording of Sean Kelly, right? So these are a bunch of different Brady violations that they're trying to argue. It's not just one. And that's what I think is the strongest portion of this appeal, because if they can show a pattern of Brady violations, I think it will be easier for them to show prosecutorial misconduct. If they can show prosecutorial misconduct, it's very likely there won't even be a retrial. He'll just walk free. And that is how it goes. Argue with your mom, don't argue with me. I didn't make these rules up. If you need a lawyer, go get one because it's not me. So is the evidence favorable to him, and was it suppressed? We got a yes and a yes, I think, on the fingerprints. I'm just going to go with that. But again, she's not only talking about fingerprints, although she is talking about that here. She's talking about DNA evidence. She's talking about Kelsey's interview transcript. She's talking about the serial number on the pew pew. Then number three, after was it suppressed? Number three, would it have changed the outcome of the trial? TORY's lawyer says yes. If the jury could have heard the full accurate picture, without all this don't be fooled and all the late discovery and all of the DNA and the physical evidence that was suppressed, it would have tipped those scales of a reasonable doubt with at least one juror to find that he didn't do this, to find that he was innocent. Now, that's her opinion. I don't know if that's true or not, but she does have to argue that. And she says, so as a result, we actually pray for the exoneration. They want him exonerated, mistrial, and no more prosecutorial misconduct. We're not doing the double jeopardy. Goodbye. She ends her speech. Shout out to Sean Davis for gifting 10 That Surprise Witness memberships. Shout out to Sean, and y'all need to say thank you if y'all got one of them. Okay, so then that's her arguments are over, and then the prosecutor gets up there, girl. And I don't think he did too good of a job. His name, Michael Keller. He says, first of all, Your Honors, we need to talk about how compelling the evidence in this case really is. Within minutes of the shooting event, cops found the pew pew under TORY's seat. Megan Pete and Kelsey Harris both identified TORY. Also, Kelsey did it almost immediately because she sent a text message to Megan's security saying, help, TORY shot Meg 911. The prosecutor goes on and says, Megan Pete identified TORY as the shooter before and after the trial. And there's 3 admissions, Your Honor. There's 3 admissions. Number 1, TORY calling Kelsey after the event. He said he didn't even remember what they were arguing about, and he blamed alcohol, but he apologized, so that means he's guilty. He confessed again. That wasn't a confession, in my opinion, apologizing for something. If he would have said, I'm sorry I shot you, or I'm sorry I shot Meg, or whatever, like maybe, but just a general apology doesn't mean he did it. I'm sorry that things got out of hand and I was drunk. Doesn't mean he shot somebody. The second admission, the prosecutor says, is later that day when he texted Meg and said, you probably never want to talk to me again, and blamed liquor. And he had another admission in the verified Instagram post, the one we just talked about, where the actual social media manager was the one that said that's not true about Kelsey doing the shooting. So 3 admissions, Your Honor, and we have all this strong evidence. The outcome of the trial would have not been any different. It would have been the same outcome, Your Honor. He says, this is the prosecutor. He says, now defendant, that appellant, TORY, he says he wasn't apologizing for shooting Meg, but instead for causing a rift between Meg the Stallion and her friend Kelsey, but this is impossible, Your Honors. There was no rift between Kelsey and Megan. And you know what his evidence for it was? Because Kelsey went to the hospital to check on Meg at the hospital. But didn't Meg also send Kelsey away and they never talked again after that day? Very interesting to me. I mean, I don't know. TORY, the prosecutor, said another reason why it's impossible he wasn't apologizing for just causing a rift is because TORY didn't apologize to Meg. So if he had actually caused a rift, why wouldn't he apologize to both of them? But he kind of did apologize to both of them because he did say, no, you probably never want to talk to me again. So this man is unfortunately have to argue out of both sides of his mouth, because I do think that there were some errors made at the trial level, which this is why I kept saying in the Diddy trial, we need to make sure the guy gets a good, fair trial. Because if he doesn't, it could all be for nothing and overturned. This is how it happens. TORY expected to receive backlash after the word got out of the shooting incident. The lawyer said, the prosecutor said, he's like, and the reason, the fact that TORY expected backlash to come out of this, it shows that he's guilty of shooting, which I don't think is a very strong argument. He said, to reiterate, the evidence in the case was compelling. And then the prosecutor said, now let me turn to some of the issues highlighted by the defense, by TORY. Let's start with the Instagram post from the verified account. He says opposing counsel mentioned something about Brady, but he claims they have no application. Oh, okay. He said basically what I said earlier, which is the Brady doesn't really apply with inculpatory evidence. Inculpatory means it makes you look bad. So that's what I was saying earlier. Like him kind of like, his official blue check mark account saying it's not true that Kelsey did it absolutely undermines his trial strategy, which was Kelsey did it. Okay. You understand where you follow so far? Like his defense theory is Kelsey shot the gun. I didn't do it. Kelsey did it. So the fact his blue check mark account is saying Kelsey didn't do it, or that's not true that Kelsey did it, does not look good. That's not exonerating evidence. That's not evidence that makes him look innocent. It's actually evidence that makes him look bad. But it doesn't make a difference under the Supreme Court standard of a fair trial. He still has the right to even inculpatory evidence, any material evidence which could affect the outcome of the trial. He has a right to see it. So the prosecutor is not wrong. Opposing counsel mentioned Brady, but it doesn't have any application because this stuff was inculpatory, not exculpatory. It doesn't actually matter. Okay, maybe not under Brady. Maybe it'd be under Giglio or, something else. But it is under the Brady progeny, which is the duty of a prosecutor to turn over all evidence that's material, whether it be exculpatory, whether it be inculpatory. If it's material evidence that has the effect to has the propensity to affect the outcome of a trial, it is implicated in a constitutional way, federal constitution, as well as a state constitution, to the right of a fair trial. So the prosecutor goes on after his little, well, technically, okay, maybe it ain't Brady, but maybe it's Giglio. It's something under Brady and its progeny. He says the Instagram posts were all turned over upon realizing they weren't turned over. And he says a lot of this Brady stuff is forfeited because they didn't raise it at trial. Forfeited. And this is where it's kind of like, wait a second. So you're like the prosecutor, you're supposed to be making sure that criminals are off the streets and that you're protecting people who didn't do crimes. Like you even supposed to be protecting people who did crimes too, once they serve their time and stuff, or if you're working out of jail or whatever. So he said they forfeited it because they didn't bring these arguments up. And I mean, that might even be technically true, that if you don't bring an argument up, you forfeit it. But like, think about the perverse hell that means we live in. Like, oh, well, too bad, so sad. Your lawyer that you hired 2 weeks before the trial started didn't do good enough objections. And our prosecutorial misconduct should just be overlooked because he didn't. And I'm not saying they did prosecutorial misconduct. What I'm saying is this is his argument. His argument is like, even if we did prosecutorial misconduct, so freaking what? Too late. You snooze, you lose. I think that's not right. I think that's immoral, actually. I think it's immoral. I think it's unethical. And I think it's actually flies in the face of his duty as a prosecutor. So you out here saying, oh, well, because somebody said forfeited their, I don't think he did forfeit it. Okay. So like, don't get too like, worked up over that. I don't actually think he did forfeit it because the lawyer did object to a lot of this stuff at trial level, but that's just such a non-argument, like, oh, well, technically he didn't, say it at the right time. So we should be allowed to prosecutorial misconduct all over the place and shit on everybody's rights. I mean, that don't seem right to me. But he wants to throw that in there. And he said counsel never asked to redact an Instagram post. And they didn't object on a discovery basis. So then this is when one of the judges jumps in and asks a question and says, if there were an error, like if we were to find that the judge did err in allowing this Instagram post to come in, what is your argument? Now, they're asking the prosecutor this in the middle of the judge interrupts the lawyer in the middle of his presentation and says, okay, so let's say we do find that it was admitted by the judge in error. Was there prejudice to Tory Lanez by that? And the prosecutor said no, because a lot of those questions that were asked on cross-examination would have cleared it up and casted the doubt anyway. He said and even if it were taken as though the Instagram post from the Tory Lanez verified Instagram account were an admission or a confession, it's not prejudicial because he admitted it and confessed in other ways too. And the judge, telling the judge, like, he also confessed to doing the shooting when he apologized to Kelsey, which I've already discussed. I don't actually think that counts as a confession. And he did send that text to Meg, and he did make that recorded phone call. So it isn't. And also, Your Honor, the prosecutor said, it's not like he said, I did it. That's not a confession like that. It's just saying Kelsey didn't do it. And then the prosecutor, I guess, answered the question. So then he moves on to his next point, and he says that he addresses the next point of Kelsey's recording of her interview and the transcript of the recording. He says, well, first we entered that into impeach her, to basically make her look like a liar. Now, why would the prosecutors want to be making one of their star witnesses look like a liar? It's very strange to me. I think what they really were playing it for was to get their version of the story that they liked better in that video in front of the jury. And they were like, oh, well, Your Honor, the judge said at trial, you can't consider that to be evidence. And it's like, well, Tory's lawyer's like, okay, they heard the whole thing. It was like a long thing. It was like 2 minutes. It was like an hour and something, almost 2 hours. He said, so during the arguments, during the impeachment on the direct examination, much of the recording came in to impeach her. So it was in anyway. And while she was still on direct, that's when the prosecutor made a request to the judge to play the entire recording. That, according to the prosecutor, put Tory's defense team on notice that the entire recording was going to be played. The defense had the opportunity to object and to object to portions. Now, I'm going to stop him right there because that's not what happened at sidebar. That's not what happened. So that's just not true. Maybe he forgot. Maybe he got too much going on. But the defense absolutely objected and said, Your Honor, they can't play this in open court. And the judge, you know what the judge said? It's easier this way, so we're going to do it this way. They didn't offer a headphone. They didn't offer a private screening to refresh Kelsey's recollection. No, they played it in front of the jury so the jury could hear it. So the defense really didn't have notice. They really didn't have notice. And neither did they have time. I mean, it was an 80-something page long thing, I think he said. And so he got it like after Kelsey got off the witness stand, which just I don't think is fair. But the prosecutor still barges, straight ahead with these what I consider to be false statements. He says Kelsey wasn't excused as a witness. She could have been recalled up to the stand. And the confrontation clause only comes into play when the defense doesn't have the opportunity to cross-examine a witness. And technically he did have the opportunity to cross-examine this witness. He could have called her back up to the stand. And then he moves on. In the rebut, the prosecutor addresses these the defense attorney, Crystal Morgan, addresses these arguments in turn. So I will read her rebuttals here, but the way that it works is like she got like 30 minutes, this guy gets like 15 or 20 minutes, and then she gets to come rebut. So I'm just going through my notes. But then he moves on to the prosecutorial misconduct aspect of this and says that they have forfeited those claims because the objections weren't properly raised at trial, which I actually disagree. They're arguing the cumulative effect of a Brady violation, so they don't have to have said Brady at the trial level. I don't know how California works exactly, but that is how it works from what I understand in the federal level, and these are federal constitutional rights. But there's always stuff going on that I don't understand. So, take that for what it is, grain of salt and all that. Prosecutorial misconduct. Oh, he forfeited those claims. He can't bring those up because nobody said those at trial. Prosecutor said witness was under subpoena. So this is the part about what's his name, Justin Edison. So now he addresses the Justin Edison thing. And he's like, well, the prosecutor said that he was under subpoena, and the prosecutor had a good faith basis to believe they were going to get that confession, or they were going to get Justin on the stand, and Justin Edison was going to say that Tory Lanez confessed the next day. They had a good faith belief of that. And this is a judgment for the trial court, your honors. Like, this isn't even something that's up to y'all. I mean, all due respect, like, you don't even got jurisdiction over here. So get off my, what, basically is what the lawyer, prosecutor trying to say. He said, if the defense counsel wanted more information about something, the time to raise it has already passed. They failed to object properly at trial. And for that reason, they are precluded from raising this at appeal. Objection would have been futile. Okay, so Tory's lawyers is saying objection would have been futile, like it would have been pointless to object any further than he already did because the judge would have not sided with him. And then said, have a good day or whatever. So then Crystal Morgan comes back up to do her rebuttal. She says, first of all, let's talk about that text to Justin Edison. There was a motion in limine filed by George Magdesian before trial started. This was December 12th, 2022. He said that without Justin present at the trial, that the prosecutors should not be allowed to raise it at the very least in an opening statement. Because if Justin's not going to be present at the trial, the prosecutor shouldn't be allowed to bring this forward. This has not been forfeited, Your Honor. This is Tory Lanez's lawyer. This hasn't been forfeited. I don't know what this prosecutor is talking about forfeiting. Nothing was forfeited as far as that text is concerned, and about what the prosecutor said in the opening statements about Justin is going to come in and say that there was a confession. That's a no. The lawyer, Tory Lanez's lawyer at trial, did try to have that excluded. He did know that they were going to try and say that Justin's going to come and say there was a confession. He said, he did. Crystal Morgan said, the trial lawyer did try to have that excluded. So what are you talking about, forfeit? No, wrong. Okay. There's also Tory's lawyer. The objection was not granted by the court. Okay. So then the lawyer, Tory's lawyer, moves on to say, okay, now I want to address this so-called compelling evidence in the case. She said, I absolutely disagree that there's compelling evidence. There's actually almost no evidence of the physical nature that made its way in front of the jury's eyes. There's the lack of physical evidence in this case, actually. Even today, it still isn't quite clear what exactly happened on that night. She said, now let me turn to that Instagram post that should have been excluded. The fact that Tory Lanez didn't say, it wasn't Miss Harris, it was me, doesn't really help the fact that it was inculpatory. There's really only two possible shooters. There's 4 people in the car, she said. Megan, obviously she didn't shoot. Jaquan, Kelsey, and Tory. Jaquan has been excluded for whatever reason. And he said it doesn't matter that he didn't confess and say, I did it. It was an implied confession because there was really nobody else who could have done it. And on this part right here, y'all, that blonde hair lady judge in the middle was nodding. Okay. That was the one really part of the whole thing. And I mean, I was typing really fast. Like I was looking at what I was typing. So I wasn't really paying attention to the judges. And I wish that I could have been, but I wanted to get the information more important than like that information. You know what I mean? The spoken things. But the judge, she was nodding like this whenever Or when TORY's lawyer said it doesn't matter that TORY didn't say it was me, it was an implied confession that was allowed to be seen by the jury. It was untimely turned over. This Instagram post where somebody said it's not true by using Tory Lane's blue checkmark account. It was the social media manager, Farius. Tory's lawyer said this is a reminder to everybody in the room. Brady violations occur whether the suppression of evidence is willful or accidental. So Tory Lanez and every defendant has a right to evidence produced against them in court. These instances, Your Honor, as well, were very significant. We are talking about physical evidence in the case, along the veins of fingerprints, DNA, which excludes. We're not talking about, they kept the DNA to themselves and it all just points straight to Tory Lanez and shows he's the killer or the shooter, not the killer. There's no death in this case. The shooter. That would be one thing. Maybe it wouldn't have been different for the outcome of the trial. But here, the jury never heard his fingerprints weren't on the gun. The jury never heard, someone admitting to being the one that made the post on Instagram or the comment, that's not true. They never heard that. They never heard his fingerprints weren't on the magazine. They never heard that the 90% male DNA excluded him. She said, these instances were very significant. These weren't little frivolous little things. I agree. I agree. It's the fingerprints for me is big enough alone. But then you have the Sean Kelly 911 call that still hasn't been unsealed to the defendant. I think in and of itself alone, if that is true, if I'm understanding that correctly, that Tory Lanez and his lawyers never heard that 911 call, that's a whole nother reason to overturn the whole trial. And that part is not how I feel. That's what I actually think legally. Now, again, I can't predict, anything could happen. The judges are, it's 3 of them. Anything can happen. I could be wrong. I could have an incorrect understanding, but I'm not I want to just be clear that I'm not oh, that should be overturned because that's not fair. And that's how I feel. It's no, based on my understanding of how Brady works, which I'm not an expert, but based on my understanding of how Brady works, if it's very material evidence, even if it makes you look bad, you have to have it. If it's really integral evidence to the trial, remember the Alec Baldwin Rust trial. I always go back to that because it's recent and it involves, Alex Spiro represented him. Alex Spiro, who represents Rock Nation routinely, he made these arguments and he did a fantastic job. It was the first time I ever heard of him that I remember. Maybe I heard of him before, but it was the first time I ever heard of him that I remember. And also I think he represented Mr. B. So I don't know which one came first, him or that. But he said at trial, that this should be overturned. There's a Brady violation. Now, yeah, should George Magdesian have done what Alex Spiro did and made these arguments up for mistrial at trial? Sure, should have. But that doesn't mean that he can't get a new trial. It's just, something he could have done. Okay, so Tory's lawyer is kind of giving her closing points and of her rebuttal. She says, this is just a reminder to everybody in the court that these Brady violations can happen whether the suppression of evidence is on accident or on purpose. It really doesn't require them to do it on purpose. On top of the fact that the instances of suppressed evidence were extremely significant and it would have changed the outcome of the trial. She gives an example, again, back to Kelsey's recording. She said there was an objection filed to that. Not only was there an objection filed to the Instagram post coming in, there was also a motion in limine filed to Kelsey's recording coming in. This was December 5th. And then it was objected to again at a sidebar. This is where George Magdesian objected and the judge commented, it's just easier this way. And George was overruled, but he was like, Your Honor, that there's rules. George was overruled by the judge. It's just easier this way. And this is how we're going to do it. She went back to Kelsey Harris. She said there was no body attachment on Kelsey Harris. She stated she didn't want to be here. She stated that she didn't want to do this. She admitted to lying in her previous testimony to the prosecutors. And there's no record of why George Magdesian didn't call her back, but it's likely to assume that maybe he just felt overwhelmed and beat down by all of these late disclosures and he was just, scrambling or whatever. But it was clear that it would be difficult to get Kelsey to come back. But we do know that George Magdesian did state on the record that he wakes up every day with a new email from that early that morning or late that night of why he lost, and maybe that's he lost some of his steam. Maybe he were, maybe he needed a little bit more time to prepare. And so she kind of ends her rebuttal with a sort of catch-all argument. And she says, in any event where you find that something is forfeited because George Magdesian didn't properly object, I would ask that you would consider how difficult it is as a lawyer to be thrust a case upon you and you have to deal with everything that this other lawyer did for who knows how long. And it should be basically chalked up to ineffective assistance of counsel if you do find that he should have said, oh, Brady this, Brady mistrial that at trial, because just imagine how difficult it is for him. And did, Tory Lanez really get a fair trial with all of these variables and factors on the record? And so that was pretty much the end of the oral arguments. Now, the next question is, when are we going to find out what the decision is? Is he going to get to walk away freely, mistrial? Is it going to get overturned at all? Is it going to be remanded back down for a new trial, or is it going to stay as it is? I'll tell you, I won't be shocked to see any of those outcomes. You just can never know. You can't really know based on the questions they ask. You can't really know based on really anything. The appeals court does have a 90-day window of time to issue their ruling. That's up to, 3 months. So it could be November when we find it out. That being said, a lot of times these judges already have their tentative rulings written out. They already know what they're going to decide, and they really just need to ask a few follow-up questions. Could be a situation like that. I, again, am just really not sure. It could come out, tomorrow. It could come out in 3 months. We really will just have to see. In the meantime, there's other stuff that is going on. We do have the Milagro, the Megan Thee Stallion, Megan Pete. She has sued Milagro Cooper, and when is that going to trial? Hold on, let me look at my little calendar here. Okay, so tomorrow there's a Demori Hadley hearing. Okay, there's a Shannon Sharp status check. I think that's been dismissed. Demori hearing August 29th. So September 8th, in a couple weeks, Milagro's trial. Okay, so her trial is the federal court in Miami in September 8th. That's coming up soon. And then September 9th, we have a Keefe D status update. September 10th, Meg Thee Stallion status conference with the Emilio Garcia versus Hot Girl Touring. That's September 10th. So September 8th, 9th, 10th, we have something every day. Oh, 2 things on September 8th. So 2 things September 8th. That's Drew Dixon versus LA Reid. They have a status update hearing. He's technically, I think he's in default right now. I think he owes somebody money. So there's a status update hearing. I think he's also in default in this one. But on September 8th also is the Milagro jury trial start date. Okay, so September 8th, today's August 18th. September 9th, Keefe D status update, pretrial hearing. And his trial is not till February, so that one's not, it's just a status update. Then there's the Meg Thee Stallion, another Meg Thee Stallion. So Meg Thee Stallion has a busy week this week. She got status conference September 10th for the Garcia. She's a defendant there. And then the defamation, cyber stalking, harassment, whatever trial for Milagro. So y'all let me know. No, and they're not coming back at 1 p.m. for Tory today. The Tory arguments are over. The lawyers, the judges are still there. There's other people doing oral arguments, but Tory's are over. No, they're not coming back. They are coming back, and y'all can go in there and watch if you want to, but that's not Tory. From what I understand, it's over for him for the day. And they're just, oh, academics got served for what? Two Frames Media served what? A subpoena, a lawsuit, a deposition? Okay, thank you so much, Simply Fee. Let me update that now. The Milagro trial got moved. It got moved to November. Okay. November what? Oh, shoot. I didn't know that. So thank you for the update. So we have a busy November too. That's the Jeffries competency hearing. That's the Abercrombie guy. New Milagro date there. Mangione is the defense file by deadline, November 14th. And then the key, then nothing really that I know of, December, January, but then back up in February, the Keefe D trial starts. Post discovery case conferences in February for the Fat Joe lawsuit. March, we have the Blake Lively, Justin Baldoni trial. April, we have Big U pretrial conference. And May is the Big U RICO trial start date. I have other stuff on here too, but what's the most recent thing we have coming up here today? The Tory Lanez oral arguments was today. And then tomorrow there's a DeMore hearing. I think on the motion to dismiss. I think they're just trying to get the lawsuit dismissed and not go to a real full trial. So that's tomorrow. And then there was a Shannon Sharp update thing, but I think that's been settled. And then on the 29th, there's another DeMore hearing. If the trial is not, if they decide to go to a trial in this Laura Gatz, who's trying to get a temporary restraining order from DeMore. He had to do a deposition in the Milagro case. I believe both Aiden Ross and DG Academics have been subpoenaed. That is crazy. San V said they moved it because it's all BS, and she showed them in that 600-page deposition. That's what I was gonna say. Should we read the Milagro? Not today. I'm doing it today. It's 600 pages long. But should we read the Milagro? Do y'all want me to read the Milagro deposition? Rayona saying yes, read it. So yeah, I mean, I thought, sorry, I need to check a message. I actually thought that Tory's lawyer did as good of a job as she could have. I do think that there were some perhaps missteps on the behalf of George. I think he could have even done a better or a stronger job, better arguments, stronger arguments, better job. But truly, I mean, he did way better job than I could have done. To some extent, and at some point, you do have to kind of say, all right, the prosecutors had fingerprint evidence that excluded the person who they're trying to, the defendant. At some point, we do have to say, please, this is a Brady violation, because if they could do it to him, they could do it to you. Y'all are saying read it. Yes, read it. I mean, it's pretty good. I'll tell you, I'm only on page 244 right now out of 600. So let me just go through and see how many actual pages of deposition there are. Cause I know these depositions have a lot of stuff at the back. Hold on. Let me see. I think it's, sorry, I'm just trying to find the last page. Okay. Just to see how long it actually is. If I do read it on a live, how many pages do I need to read? Looks like it's about 400 actual pages. Yeah, if he would have been on the case from the beginning, I think he would have did an excellent job. I mean, I think the judge should have given him a little more time to prepare. I don't know if he asked for that or not. Yeah, the glossary is, there's 200 pages of stuff in the back. So yeah, okay. So just to recap, the TLDR, is the TLDR, TLDW is the Tory Lanez appeal is really based on three major pillars. Number one was the confrontation clause, which is the Sixth Amendment. That was not being able to adequately question Kelsey on time, having all the materials they needed for those transcripts and stuff. He didn't get the transcript of that interview with her, which was played to the jury until after she wasn't even there to ask questions anymore. Second pillar of the arguments are the opening and closing statements that the prosecutors made. And the third pillar, and I think the strongest one constitutionally, is Brady violations. Favorable evidence to TORY, which was untimely disclosed, which was not turned over until or unless his lawyer asked for it, or it came up way later, or oopsie daisy, we didn't know. Again, if you just look over at the Alec Baldwin Rust trial, it was a box of bullets that the pew pew bullet came out of. It was stored down the street in a different warehouse, and the whole thing got mistrialed. Okay. Mother Oates said, in my opinion, I think Sean Holly should have the day she deserves. Agreed. Okay. Simply Fee said Sean Holly used up all the continuances and quit during the middle of trial. I hear you. And I'm sure that's what the judge said and stuff. But like when a new lawyer is coming on, I feel like there should just be a new continuance for that one lawyer. Like Sean Holly using up all the continuances shouldn't even be allowed. You know what I mean? Like if you have to have a new lawyer come on, they should have a month, like please. Apparently he only got 2 weeks. Yeah, it's 600 total. Yeah. Okay, so Rihanna said, question, if the court decides his trial wasn't fair, do they do a retrial or will they just release him? So from what I understand, it depends. They have the option to do a few things, but it depends on which exact thing that they find wasn't fair. Like was something admitted into evidence, for example, something admitted before the jury that they shouldn't have seen, but it didn't really affect the outcome of the trial anyway. In that case, technically maybe something wasn't fair, but he had ultimately a fair trial. It's going to come down to like little nuanced stuff like that. So the short answer, it depends. It depends. Shout out to Diddy Docket. Thank you for covering this. Like you, I did not watch this trial in real time. It's clear he did not get a fair trial. So Diddy Docket is kind of on that fence of like, it's clear there's not been a fair trial, but also didn't watch in real time. Let's see. Shout out to Monica. Thank you so much for supporting BJ. If you would like to donate to me for purchasing documents, you can shout out to Monica to put the cash out there. Yeah, it's all linked below if you want to. Okay. Well, I don't want to make this video too long. I want people to be able to like come in and know what happened at the thing without it being a 3-hour long video, but I'll be back on here tomorrow. I don't exactly know what I'm going to do yet. I mean, the thing that comes to my mind most immediately is maybe the Milagro transcripts, just so we can start getting up to date on that case before that one comes around. Because that one's coming up in, I guess, about 3 months. So maybe something will happen before then or something. I'll decide in the meantime. But in any event, I'll see y'all probably tomorrow. That's all I read for this one. In the meantime, facts ain't defamation. Neither are opinions. I don't know. I wasn't there. Love you, Mina. Okay, bye.